There are sometimes extremely important Supreme Court decisions that you've never heard about that touch on the Second Amendment, even though they're not specifically about the Second Amendment's right to keep and bear arms. I'm going to talk about such a case today, the Espinoza case from 2020, a huge deal in support of our Second Amendment, and yet it touches on the First Amendment. Stay tuned. Let's talk about it. Hey folks, I'm Mark Smith, host of the Four Boxes Down, a proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and New York Times bestselling author. If you haven't subscribed to the Four Boxes Down, our Second Amendment channel, please do so and show your love for the Four Boxes of American Liberty. Okay, folks, so let's talk about something really quick. There's a very important case I'm going to teach you legal geeks about that's super helpful to the Second Amendment. You may not know about it because it's not a Second Amendment case, but you're going to want to know this one, and you're going to see why it's so helpful and important to our right to keep and bear arms when I explain it to you. So begin. The case I want to talk about is a U.S. Supreme Court case from 2020 called Espinoza versus Montana Department of Revenue. To make a long story short, the Espinoza case dealt with the use of tax credits for the state of Montana as to how donations were made and how they were treated for tax purposes involving private schools. All you need to know for the purpose of this discussion of Espinoza versus Montana is that the state of Montana treated donations and tax credits for people that went to non-religious private schools differently than the way they treated them if people went to religious private schools. Specifically, if you went to a religious private school, you were not treated the same. You were actually treated worse than if you went to a private non-religious school. There was a challenge made to the U.S. Supreme Court under the First Amendment, which is part of the Bill of Rights, of course, under the First Amendment's free exercise clause, saying that this rule that discriminated against religious-based private schools and favored non-religious-based private schools violated the free exercise clause of the First Amendment. And the U.S. Supreme Court says, yes, that's true. It violates the First Amendment. Now, you may ask yourself, well, Mark, this is an interesting case, but why do I care about a First Amendment case dealing with the free exercise of religion clause and the state of Montana discriminating against religious private schools and not harassing non-religious private schools? The reason why this is so important is the methodology, i.e. the way the U.S. Supreme Court went about interpreting the Bill of Rights, because it really teaches us the proper way to interpret the Second Amendment, at least to a large extent. The Espinoza case was written by Chief Justice John Roberts. Now, what Roberts wrote basically was that the key time period for interpreting the meaning of an aspect of the Bill of Rights, in the Espinoza case, it was the First Amendment. Of course, in NYSERPA versus Bruin and Heller, it's the Second Amendment. Same idea, though. It's all part of the Bill of Rights. Remember, the First Amendment was adopted in 1791 with the rest of the Bill of Rights. So understand how to interpret the First Amendment when adopted in the same time as the Second Amendment. These are helpful. The reason why this is so important, and you'll see why this is hugely important, and for those of you who are judges or law clerks or lawyers out there, you're going to really want to look at this Espinoza case because it's extremely helpful for the home team, the pro-Second Amendment community. So the way this Justice Roberts decided Espinoza is he went back to 1791 at the time of the founding, and he specifically interpreted the First Amendment as it was understood at the time of the founding. So that's very good. The reason why this is so good is because, as you know, the anti-gun community is desperately trying to interpret our Second Amendment rights by trying to persuade judges to improperly, in my view, look to post-Civil War history. That would be late 19th century history after 1868, the year the 14th Amendment was adopted. And the anti-gunners are desperately trying to get the courts to look to that time period for interpreting the 1791 Second Amendment. Now, this is not proper for many reasons, and then I'm going to give you the most powerful reason of them all when I get to this Espinoza case in 1 second. First of all, as you know, the Second Amendment was adopted in 1791, so if you're going to try to understand what it meant, you have to look to what the people who adopted it understood it to mean, because they're the ones that wrote it and ratified it. Obviously, by the time you get to the late 19th century, everyone who wrote and ratified the Second Amendment and the First Amendment are now dead. So it's the wrong time period for that reason. Second of all, as you know, when the Second Amendment and the whole Bill of Rights was first adopted, it was designed specifically to restrict the actions and the power of the federal government, not the states. That came later after the 14th Amendment. Now, the reason why this is important is the Supreme Court has made it very clear that the scope of the Bill of Rights, including the First Amendment and the Second Amendment, has to be treated equally, meaning they have to have the same meaning, the same understanding, the same scope, and the same authority, whether you apply the Second Amendment or the First Amendment to the federal government or to the state governments, which means it has to have a single meaning. You can't have a 1791 understanding of the Second Amendment as applied to the federal government, and then an 1868 understanding and meaning of the Second Amendment as applied to state governments, simply because, the states, it was not impacted by the Second Amendment until the 14th Amendment in 1868. Now, the reason why this Espinoza case is so great for us is as follows. The state of Montana and its supporters in the Espinoza case were trying to justify the discrimination against these religious schools. And how did they do this? You're going to be very happy when I give you this history in 1 second. Specifically, here is the argument advanced in support of the Montana position, which lost to the 1791 understanding of the First Amendment. Here is what the Supreme Court wrote in Espinoza about the view against the First Amendment. Tell me if this rings a bell for those out there involving the Second Amendment. Quote, the state of Montana argues that a tradition against state support for religious schools arose in the second half of the 19th century as more than 30 states, including Montana, adopted no aid provisions. Hear what I just said? The argument against the plaintiffs in Espinoza, the argument against the First Amendment violation was that Montana argued that the tradition arose against state support of religious schools in the second half of the 19th century as more than 30 states, including Montana, adopted no aid provisions. Sound familiar? Again, in Espinoza, the anti-freedom people were arguing that late 19th century history, the fact that 30 states adopted these provisions, somehow should inform the understanding by Justice Roberts in the Supreme Court of the 1791 First Amendment. And what did the Supreme Court say when they were confronted with that argument that 30 states in the late 19th century passed those laws, and that should be the basis for reducing the scope of the protections of the First Amendment's Free Exercise Clause? The Supreme Court said exactly what you wanted to say if you support the Second Amendment. The Supreme Court said, quote, such a development, of course, cannot by itself establish an early American tradition. It goes on to say that, quote, it was an open secret that sectarian was code for Catholic. The Blaine Amendments, which was what we're talking about, those late 19th century laws, was born of bigotry and arose at a time of pervasive hostility to the Catholic Church and to Catholics in general. Many of its state counterparts have a similarly shameful pedigree. Sound familiar? The Supreme Court is saying, we're not going to trust late 19th century history, even if it's 30 states that passed that law, because A, it's the wrong time period for understanding the 1791 Second Amendment to go to the late 19th century, the late 1800s. It's the wrong time period for telling us much of anything, if anything at all. Beyond that, they point out that the late 19th century laws that the government was relying upon to overcome the First Amendment claim were born of a shameful pedigree against Catholics. Question: how many of the anti-gun laws that the anti-gunners are relying on that were passed, the anti-gun laws were passed in the late 19th century, that the anti-gunners are trying to rely on to establish a tradition, a history of tradition of regulating firearms in America? How many of those do you think were born of a quote-unquote shameful pedigree, except as to blacks, to African Americans? I'm guessing almost all of them. Do you see the similarities here? So in the Espinoza case, 30 laws passed against the First Amendment in the late 19th century were rejected as not persuasive by none other than the Supreme Court and Chief Justice Roberts in the Espinoza case in interpreting the First Amendment, which was adopted the exact same day as the Second Amendment. And moreover, the court specifically acknowledged that the fact that most of those laws adopted in the late 19th century were born of a shameful pedigree, i.e. discrimination against Catholics. That sounds a whole lot like an analogy to late 19th century gun control laws acted as part of a shameful pedigree against African Americans in the South. You see why this Espinoza case is so powerful for us? So to close, when the anti-gunners are desperately trying to argue that late 19th century gun control laws should be part of the long-standing history of the tradition of regulating firearms in America, and thus is a basis for reducing the scope and understanding of the Second Amendment's right to keep and bear arms, which when it was adopted in 1791, you obviously know that it's the wrong time period, because everyone in the late 18th century, no one in the late 19th century would have any idea what the people in the 18th century said, because all the people in the 18th century were dead. And beyond that, in the Espinoza case, the Supreme Court specifically rejected 30 state laws as inconsistent with the First Amendment, and that was not enough to effectively amend the text of the First Amendment. So again, by analogy, even if the anti-gunners could come forth with 30 states enacting in the late 19th century anti-gun laws, gun control laws, that would not be a basis for concluding that the right to keep and bear arms should be limited in any respect, because it's the wrong time period, and there's no way they can find 30 states. And even if they could, as we learned from the Espinoza case by the U.S. Supreme Court, written by Chief Justice John Roberts, it's just too late in time. And more importantly, the motivations behind those laws. In the Espinoza case, it was anti-Catholic bigotry. And in most of the gun control laws we talk about from the late 19th century in the South, that was motivated by anti-African American or racist sentiments. And it should not be a basis for courts to use to restrict our fundamental right to keep and bear arms. And that's what it is, a fundamental right. And when in doubt, we win, because the presumption is, once the text of the Second Amendment applies to a modern-day gun control law, the presumption is it's unconstitutional, and it's up to the government to come forth with a powerful historical evidence based on a tradition. They have to show a tradition of firearms regulation when they look to that history at the time of our founding, and not the late 19th century. And not only is that true for the Second Amendment's right to keep and bear arms, but obviously it was true in the Espinoza case against Montana in 2020, as Chief Justice John Roberts and the rest of the Supreme Court found. So again, if you support the Second Amendment and you want to get super geeky, check out Espinoza versus Montana Department of Revenue, 2020, Chief Justice Roberts' decision. You'll like it a lot. Very helpful. Okay, folks, hope you learned a little bit something here today at the Four Boxes Diner. If you haven't subscribed, please do so, and we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.